Right, okay, so we're just going to get started, everyone. So thank you. Welcome to our IP Considerations event. We're happy to have you guys here. Just to give a couple of announcements before we get started into the event, just want to remind everyone that we have some upcoming events. This Wednesday, we have the We Lift, Becoming the Entrepreneur You're Always Meant to Be. On November 11th, we also have the Polished event we're excited for. And then at the end of November, we have Seed for Startup, which is going to be over in the auditorium over there. It's going to be very akin to a Shark Tank. We're going to have students showcasing their business models and pitching them to investors. So if you wish to participate and come view that, there will be audience participation in it. And if you're a student, we highly encourage you, if you want to be a part of the event, to get in contact with me so we can get you set up and scheduled if you want to pitch your business idea for that. So that's it for announcements. We are now going to turn our time over to Eric. So let's get over here to the slide. Here we are. Eventually it'll present. Let's see. There we go. Okay. Well, Eric, we can give you an introduction, but why don't you just come on up and introduce yourself. Tell us a little about who you are, what you do, and what you're here to teach us about.
Sure.
So
And I'm mic'd up. And this is the clicker? Yep. Excellent. Well, thank you for having me here today. You guys drew the short straws as far as having to listen to an attorney. Most people don't like to listen to an attorney. That's never fun. An attorney that talks about intellectual property law, I mean, that's even worse. During lunch on Halloween, I mean, this is, it can't get much scarier, right? This is pretty as scary as it can be. I thought just to kind of loosen up the crowd a little bit, to get us going first, we have to do a couple just trivia questions about Halloween movies, if that's all right. And if you answer it correctly, you get some candy. And I have to be honest, I'm not a scary movie person. I avoid scary movies. So I'm just going to assume these answers are correct. They're just off of the internet. So you can feel free to debate it if you don't think it's right. So here's the first question. First one to raise their hand. If you get it right, you'll get some candy. Which movie franchise features a haunted baby doll other than Chucky?
Specific one. There's a lot of ones.
Okay. Specific, lots of ones. That wins for me. All right. I think there's, for someone that just knows nothing about scary movies, there's a lot of them. There you go. Okay. Annabelle. Okay, that's actually was on my list. Annabelle. Okay, very good. What does the girl from The Ring whisper on the phone?
like 7 days.
7 days. You got it. Okay, maybe one more, two. What is the name of the scary clown from the Stephen King franchise It? Scary. Okay, back here. Pennywise is correct. I'm gonna. Hopefully this doesn't damage your. Oops, sorry. Anyone like Almond Joys around here? Yeah. Anyone else? All right. I gotta empty the bag of Almond Joys. It has got to be the grossest candy there is. And any suckers I can find to take Almond Joys. There you go. There you go. And anyone else? But you have to eat it. You don't have to eat it now, but you have to eat it. Oops. You'll take one?
If you got any others,
oh, sure. These things, they stuff these bags full of them because they know no one wants them. Okay. All right. Thanks for playing. All right. I guess I've got the control. Let's get that mug off there. Oh, this is a thing I saw a lawyer joke, but it's only funny for lawyers, and then even then it's not so funny. So trick-or-treaters, honey, there are some young trespassers here who want us to compensate them with candy in consideration for their promise to refrain from performing intentional torts to our property. That's how attorneys, that's how we hang. That's Okay, just a little bit about myself and then we'll get going. So my name is Eric Gardenier. I actually work here at Utah Valley University. I work in the legal department. Prior to working here, I've worked at several different companies and law firms. A couple of law firms, Snell and Wilmer, ALG, and then I've worked at some hardware companies, Intel, Motorola, some software companies, Novell, Altiris. I have a Bachelor's of Science in Electrical Engineering. I'm a nerd. And I got my JD as well at Arizona State, and I'm a registered patent attorney. So that's who I am. And I love Japan. I lived in Japan and worked in Japan for over 4 years, including 2 years in the legal department over there. And so anytime I can get over there or talk about Japan, if you decide you want to talk about Japan as opposed to intellectual property, we can do that. Okay, so we have ultimately about 50 minutes, and we can go shorter if people start to kind of like pass out or kind of go comatose. But we have up to 50 minutes to talk about intellectual property. What I was thinking is maybe if I could get some ideas of what we want to talk about, and then I'll gear our discussion around those topics. Does anyone have? Yeah, I'm going to sit down and just write these down. Write these down.
Definitely going over designs, especially in like prototyping, what to do in the early phases of a design that you're building. How to like look up who's already may have made something like that, so you don't take any of their intellectual property, but also making sure that yours is protected and no one else can steal from you on that.
Okay, perfect. Anyone else have some topics?
I'm interested in learning about how to deter patent trolls, like those. That's because I despise what they do, going and preying on people who should have the rights to be able to use that intellectual property. So that's
Okay. You don't like patent trolls. All right.
Just how to deal with them.
Any others? Any other general? Yes, sir.
I'm teamed with a couple of students here. I'm a student here too, but we are starting a new sport. How do I own that?
Okay. Anyone else? Yes.
So, already applied for something and it was denied. Could you address maybe that?
Sure.
We applied for trademark.
Okay, so there was a trademark. Okay. Yes.
I want to know how far you have to go to keep yourself safe, basically, from like law issues.
And I'm realizing probably the camera doesn't pick up the questions maybe, so I should probably restate the questions. But how far you need to go to, you said, to be safe
Yeah.
if you have a new
We're an
product?
LLC. Well, I mean, we're an LLC, which helps keep you like safe, but like trademarking, like certain things. Just curious about that.
Okay, so how to keep yourself safe, trademarks, LLCs. I saw one more hand.
Wasn't me, I was
What?
going to say NFT, but it's only
Yeah, thanks, August. I worked with August a few weeks ago on some NFT issues, and so he's here to take photographs and to heckle, huh? Awesome. Well, we have a great list of some things to talk about. There's a few things I want to talk about too, just to kind of set a framework and kind of have us all on the same page. And the great thing is we can talk for hours. I mean, we have enough material that we can talk for hours, and really would need to talk for hours to get into all the nitty-gritty of many of the things that I sense that you have questions about and are asking. Recognize that just at law school alone, there might be 3 or 4 different classes you can take on intellectual property related issues. You take a semester course on patents and copyrights, trademarks, on torts, and contracts, and so there's a lot of material. So we're not going to be able to become experts in it all today, but we can learn enough that we can kind of maneuver it a little bit, and then just know that I work here. I'm always available to talk about general questions. As an attorney, I represent the university, and that's who my client is, and so I have to be careful that I don't pick up any other clients when I'm talking about things, but if we talk about things generally enough, then I'm not necessarily giving you legal advice, and that's the balance I will have to kind of tread so that I make sure that I'm true to my client and the ethical rules that I have. But so I'm always available, and then there's a lot of people professionally that are around too, and just by learning a little bit more, that you know that you can go to them for some of these specific questions as well. But let's talk, and I'll try to leave us some time, maybe 10, 15 minutes. So if I go for 30, leave us 10 or 15 minutes, and then we can address questions of these types that I haven't answered yet, or new ones that come to mind. And then I'm available afterwards as well. The one thing I just wanted to kind of set the framework for it all, and this is what I consider the most valuable item in business, is exclusive business innovation. As you're creating a business, you're innovating, you're creating, but to the extent you can exclusively own what you've done, it creates a huge advantage for you in the marketplace. If you don't own exclusively what you've done, other companies, when they see you're successful, they'll jump in, they'll copycat, they'll try to mimic what you're doing. They can undercut maybe your pricing, and pretty soon your margins drop, and it can be difficult to stay in business. If you have exclusive rights to what you're doing, you can look at those others that want to jump in too, and you can prevent them from playing. You can kind of keep the sandbox to yourself, and that has a lot of advantages. And the way we do this, the way we have exclusivity in our business innovation, is through intellectual property. And the slide here just says, we have laws in our country and many other countries that protect property. Gives you the right to use property that you own. And we deal with property all the time in our lives. Real property is something we deal with. When we buy land, you buy a house, and you have something that's fixed to the property, or the property itself, that's real property. If you buy it, you record it at the county office, you can, generally speaking, you can now do what you want on that piece of property. There's some ordinances and different things that can come to play, but you have the right to use that property how you want. Personal property, so things other than land, but you have a nice car, or you have anything that's movable that's valuable to you, that's yours. You have the rights to use that. And if someone wants to use your car and you don't want to let them use your car, you don't have to. That's your car. Well, the same thing holds, so this is called tangible property. Real property and personal property are tangible property. There's also intangible property, and intangible property is intellectual property. And it's crazy to think about it, but what your mind can come up with, things that your mind can create, we have laws that say you can protect and own those intellectual creations of yours. It's amazing, and maybe not surprising. I remember a discussion 20-something years ago I had with someone. They were talking about the problem in China, about all this counterfeiting and piracy that was going on, and how do we stop this? And if you really think about it, that's a really difficult problem. in the sense that to the extent in China, individuals can't own property, and that's how I understand in China. Maybe you can lease property, but an individual can't just own property in China. If you can't own real property, and something like that we can touch, to say to someone they're living in that country, but we want to be able to require that, or people that come up with something in their mind, they can own that. I mean, that's a whole nother level. I mean, if you can't own property, but somehow something in your mind that you create is something that someone can own and stop others from using. So that's why I think some of these problems we have in some of these other countries are difficult to resolve, because they don't have property laws the same way we do. But in our country, property can be protected, whether it's tangible property or whether it's intellectual property, property of the mind. And then just one slide or graph to show, and it's amazing to think. This is looking at the S&P 500, so there's some top 500 companies in the U.S. at their market cap. In 1975, if you looked at what a company was worth, 83% of the value of that company is based on their tangible assets. So their land and their building and their materials and their machinery. And 17% of the business is based on intellectual property, the intangible assets. And then as you go forward in time, you see how intellectual property becomes more and more valued in a company, to the point of, in 2020, 90% of a company's value, this is the S&P 500, is attributed to intellectual property. So intellectual property is key to growing the value of your business. And the reason it grows the value of your business is because we talked about it. When you own intellectual property, it gives you exclusive rights to prevent others from doing something similar. When we talk about intellectual property, there's 4 that we'll talk about today: patents, copyrights, trademarks, and trade secrets. And this is what I was talking before. What's intellectual property? It's the product of the human intellect that the law protects from unauthorized use by others. So you can start a business, you can run a business that does not have intellectual property, and that's fine. There's many successful businesses. I could own my own plumbing business, be a plumber, and you can be a millionaire as a plumber. You go do good work, be honest, run your business well, and you can make a really, really good living. But if you were the plumber and you came up with some new gadget, maybe a plunger that worked really well for a toilet and didn't, such that it didn't splatter, and it was, created a lot of force down into the toilet, and it was really effective. You patent something like that as a plumber, you're going to be making millions and millions of dollars, and it really expands what you can do if you have intellectual property associated with your business and you're able to protect it. Okay, we good so far? Can I tell you a story about my friend Steve? Okay, good. That's the right answer, because if you said, no, I don't have any more story, I only have a story about Steve. Steve and his wife, Kim. Let me show you. Have you guys seen one of these things before? The blender bottle? They're kind of cool. Whoops, they're kind of cool and simple. In fact, you guys can pass this around. Here, you can pass that little thing around, that wire whisk, and I'll talk about it for a second. So, and I tell you this story about Steve just hopefully, I guess for 2 reasons. One, to cement this idea of how powerful intellectual property is and why it's important to determine what kind of IP you have in your business, and the importance of trying to protect it. And also maybe to fire you up a little bit and get you excited. I worked with Steve at a software company 20 or so years ago. I was in the legal department. He was in sales. He was in channel sales and worked with resellers and distributors. And Steve liked to cycle. He was a cyclist, and he's the one that introduced me to the Tour de France, and that's when Lance Armstrong was going big, and before all that stuff that was going on with that. So he pulled me in. I was really excited. And he was telling me one day about how he likes to drink protein drinks, but it just doesn't mix very well. I mean, again, this is a guy, he's a computer guy, but his mind is just working. And so, you know, while he's at lunch or after work, he's just kind of creating. And he told me, he says, I was thinking about it. He says, you know those paint can or those spray paint cans, to shake the paint inside, you shake it up and down. There's like a metal BB or something, pellet in there, a ball that helps stir the paint up. You know what I'm talking about, right? And he says, so he decided that was going to be the way to maybe mix a drink better. So he got some different metal balls and put it in a container and tried to shake it around and maybe had some success, limited success, but decided that was there was still more that could be done. And then he came up with the idea. He was working, I think they were cooking some pancakes or something one morning, he and his wife, and he was using a wire whisk to make the batter. And it clicked in his mind. He said, what if I took that ball and then formed it out of a wire, like a whisk, and used that? And he went to the hardware store and bought some wire and started kind of forming it in different ways, trying to figure out how to do it. And you'll see as it passes around, it's cylindrical, but the way it's wrapped, it actually can compress flat too. So if you have this in a bottle and you're shaking it, it's like a whisk, but then it kind of can deform while it's bouncing up and down, and that just helps stir the product. And he found it worked really well. And so Steve did, he was still working at the software company, still working hard under his job responsibilities, but he thought, I'm going to try and file a patent on this thing. And he got it with a local patent attorney, and I might even have a slide of, they decided what was patentable was going to be this wireframe spheroid. How's that? That's a mouthful. But that's what was unique. Obviously, having his bottle by itself is nothing exciting. And for something to be patentable, it has to be something that's unique. It's never been done before. So it's combining this bottle with this spheroid. And I'll even pass this around. You guys can just look at kind of what a simple bottle it was. But there we go. So this is the front page of the patent application that was filed. It issued it as a patent. He had a couple different embodiments. This is the one that you see that's in the product right now. He came up with some designs where you have one spheroid inside of another spheroid, and some other interesting designs. But he filed it, got the patent, it issued. Then the other thing he did is he's still working at the software company. He thought, I wonder about making this, if I could sell it, how it would work. So filed the patent application, and then in China, he was able to get hooked up with someone, and they made 2 molds for him. He spent, I think it was $10,000, which is a ton of money. I mean, and certainly a lot of money for him, but he thought, I'm going for this thing. So he had them design 2 molds for injection molding that was the shape of this bottle that you guys see, and has this patent application that's pending at the patent office that they're working through. And he decided, you know where this would sell great in a store that he went to a lot was GNC. So he hooked up with GNC corporate and said, I'd like to sell this. It works great. They said, no, thank you. So poor Steve, right? What's he going to do? He's just spent $10,000 on the mold. He spent another probably close to $10,000 in the patent application. So he invested $20K because he wanted to just be an entrepreneur and go for this. He then went to the local GNC just here in town, and they have a special rack where you can have local products. I don't know if they still do this, but each store has the ability to sell some local products in their store. And the local store said, yeah, we'll sell some of your blender bottles. He did that, and they took off. It's just started selling here in Utah County like crazy. So much so that GNC corporate, I guess they check on how the stores are doing and see whether these racks of these, local racks, how they're doing. And they said, what is this product? And it was the one that they had turned down earlier, but they said, oh, we want to sell this nationally. So GNC picked up the product. And then from there, Steve hooked up with Target, Walmart, Bed Bath & Beyond, and boom, they're just selling like crazy. When they start selling like crazy, what do people want to do? They want to jump in and copy. The first thing that people did was they just started making the exact same product, just like this ball and the cup. Maybe they were even using the same mold from China. I don't know, right? And they're coming in. The patent is now issued, and now Steve's able to go and say, because of this patent, you only get a patent is good only for the country that you get it in. So he's got one for the United States. But a patent prevents anyone from importing into the country. So anyone that was trying to import the product in, he could shut them down. Anyone that was trying to make the product in the country, the patent shuts down. If you sell the product, that gets shut down. If you offer to sell the product, that gets shut down. If you're using the product, I mean, he could go to individual users and say, this patent infringement, you need to stop using it. But that's not real effective use of your funds. You want to target the distributor. So anyways, he was able to start shutting down all these fake goods coming in. And that does cost some money. I mean, some he would send a cease and desist letter to, and they would immediately just stop. Others said, no, thank you. We'll see you in court. But as the money's starting to come in, he was willing to invest that money with some attorneys and start fighting these things in court, and he started winning. So then what happens is, okay, we can't mimic this exactly. So then other companies say, well, we can do something. We're not going to do a wire spheroid. We're going to do like this ball here, this kind of indented plastic ball. And you can see another one here. Here's one where they did a wire thing, but they didn't do it in a sphere anymore. They did a different shape. So all of these, per the patent, were fine. None of these infringe the patent. So you can go out and see these, in the marketplace. But it's just not quite the same. It doesn't work quite as well. And he marketed it on his website. Look for this ball. This is the original. This is what works the best. And so he said, on his website, it says, look for the Blender Ball Whisk, found exclusively in Blender Bottle brand shaker cups. When you see the ball, you know you have a Blender Bottle brand shaker. You also know you can count on a smooth shake. So he is able to exclusively get those rights to that shaker ball, and then be able to market towards it and get the consumers to know this is what they want. This is the real thing. This is one more thing from his website I just saw last week, and I just cut it out because it shows that Steve gets this whole idea of this exclusivity, the importance of being able to protect your intellectual property. They're talking about their mission statement for the company, our method. We're creators, not copyists. We refuse to produce a product that is common or ordinary. Our passion and creativity are in the very DNA of everything we make. They don't want to make things that are common or ordinary. And it's not just the fact that they're creators. That's how you make money. You don't want to do something ordinary. You want to do something different so that you can protect it as being unique. And then he makes huge margins. I mean, his bottles probably cost 15 cents to make, and he sells them to distributors, $6 or $7 a bottle, and you start thinking about what your profit margins are on something like that. And then as Steve gets this, I looked on his website. Now he understands this. He's got more money coming in. If you go to his website, here is all the protection. These are all patents now he's got on not only this bottle, but a bunch of other products he's making. And he's kind of creating the sandbox where other people can't compete. And it just goes on forever. This is more, patents that just, he goes for the different products. On this GoStack product, he has patents in all these different countries. And he goes through, he probably had 100 different patents now on his website. So this is a company that Steve and Kim started 20 years ago. And this is their building here in Lehi. I don't know if this is accurate. It's on the internet. Same place I got those answers, those questions on the scary movie thing. Who knows if it's right. but Rocket Reach says that they're doing 59 million a year now. Not bad for a cyclist who was working at a computer shop and was just doing this on the side. So that's the exciting story, okay? One other thing I want to do real quick is just make sure we're all talking about the same things as it relates to intellectual property. I hear people use the terms trademark, copyrights, patents synonymously. They kind of and that's fine. These are words we don't use all the time, but let's make sure we're talking from the same place. And so I want to just explain the difference between patents, copyrights, trademarks, and trade secrets using a guitar. Anyone like the guitar? Does anyone like to play the guitar?
Yes, sir.
All right, I see some guitarists. I'm a wannabe guitarist. I own 2 guitars. I have acoustic and an electric. My neighbors do not like when I pull it out, but I love it. So I'm going to use this as an example to explain the difference. Okay, this is a Gibson electric guitar, the Les Paul Gibson, one of the top 2 most famous electric guitars out there in the world. They, in 1950, invented a new pickup for the guitar. When you play electric guitar, the strings go and they vibrate, and you have a coil that's underneath here that's wrapped, and it detects the electromagnetivity. It detects the wobbling of the strings, and that converts into a current, and that plays out. Problem is you get other sound. Because of electromagnetism, you can have other interference that can happen, and so you don't always get a real clean sound, or you can have a buzz or a hum. You hear that sometimes with speakers when you're listening to them. Gibson came out with the idea, we're going to do a coil, and we're going to do a second coil, and we're going to wrap it the opposite direction. We're going to reverse the polarity, and by doing that, by having coils in 2 opposite polarities, it's going to reduce this interference that happens. And they got a patent on it. And the guitar sounds great. It's got a really neat sound. That's a patent, okay? They have the rights to use that for 20 years, and no one can use it. They also have a trade secret. Trade secrets are where you have a certain way of doing something in your business that is helpful, it's valuable, and you choose to keep it confidential. And you're allowed to do that too. With a patent, you're disclosing to the world how you make something and how you use it. And in exchange for disclosing it to the world, the government gives you a limited monopoly for 20 years to use it. Trade secrets, you could choose to keep it secret forever if you want. You could be Coca-Cola and say how we make our Coke, or KFC, our whatever it is, 11 herbs and spices, whatever they have. The way we do it, we're just not going to tell people. We're going to keep it secret. We're going to tell our employees they can't share it. We're going to make them sign confidentiality agreements. And that can stay a trade secret as long as it's not generally known and that you're making efforts to protect it. So Gibson has a trade secret as far as how the guitar is manufactured and the process that they use and how to laminate the wood and such. Gibson has a trademark. The trademark, if you look at the headstock of the guitar, you'll see the word Gibson, and that's how you know as a consumer when you're buying something that this is a Gibson guitar. I see the Gibson trademark, that's a Gibson guitar. So we've talked about, so patent is this invention that's here with the coils. Trade secret is a secret kind of manufacturing process they have. The trademark lets people know I'm buying a real Gibson Les Paul. And then the other thing I just haven't talked about is copyrights. If any of you know Led Zeppelin, Jimmy Page and Robert Plant, using that guitar, wrote Stairway to Heaven. And this song is considered one of the most iconic rock songs ever. And they own copyright in, let me go back, the notes and lyrics. So when they compose this, they own the copyright in the notes and the words. And then as they performed it and recorded it in a studio, they also own a copyright in the recorded sound recording as well. Okay, that's a sum of, one more principle I want to teach. That we've gone through patents, copyrights, trademark, trade secret. Something that a lot of people don't know is they actually can overlap. There are some things that can be protected by a patent and a copyright, or by a trademark and a copyright. And so there's overlapping portions. And so a good attorney is going to try to figure out if there's multiple ways to protect something in your business, because they all have limitations. I told you a patent only lasts for 20 years. Copyright lasts for 75 years. Trademark can last indefinitely. So they have different lengths of durations, but a patent is really strong and stop anyone from making, using, selling, importing the device. Copyrights are more for kind of artistic works, literary works, and trademarks. So just a couple quick examples. The Word software program, that is protected under copyrights and patents. A computer software program is copyright protected. Think of that like a book. It's a literary work. It also has utility. It has function. It causes a machine to do certain things in a certain way. And to the extent that's creative and unique and different and not obvious, you can get a patent in that as well. Star Wars. George Lucas, is that who wrote George? Okay. George Lucas, so he wrote the script. He has a copyright in the script. But then and made a movie. There's a copyright in the movie. But then he went out and became a licensing house and said, if you want to use the Star Wars trademark, you have to pay me money to be able to use those marks. And he manages those marks. So he was able, with Star Wars, to get copyright and trademark. Blender bottle, we just talked about. I talked about how that patented wire whisk that Steve and Kim have, that fits right into here. It's patented, and it's the key part of his trademark. You'll see his whisk. He uses that as his mark to identify his product. So he's getting two bangs for the buck there. And then last one, a Coca-Cola bottle is something where it actually falls in the sweet spot of trade dress, where you can actually get a copyright on the way the way that bottle looks. That's really unique, and only Coca-Cola makes a bottle like this. They have a trademark in that look, and originally they had maybe even some patents on how that bottle was manufactured a certain way, and there's something called a design patent that also they're able to get. So they used all three of these forms of intellectual property to protect this bottle. Okay, let's talk, let me just look here. Let's talk a little bit about Let's talk for a second just about patents. I told you they're good for 20 years from the date of filing. They're expensive. A patent might cost $8,000 to $10,000 to file it. And then it might cost another $8,000 to $10,000 to go from filing to issuance, where it becomes an actual patent. When you file something, it goes to the patent office, and they look at it, and they have to make a determination. These are the 4 requirements they're looking at. Is what you're doing, is it an invention? Does it have utility, a function to it? And so yes, that's an easy one to get. Is it novel? Is it the only thing out there in the world? Is it the only thing? Is it unique? Yes, and that actually is oftentimes not very hard. You might think, to say I'm the only one in the world that's doing this, can you say that? But a good patent attorney can help you too. There's always something different, right? It's like you've folded this here, and is this type of material, or you've got a notch here. what you're making is different than everybody else in some way. So that's usually not that hard. This is the hard one, non-obvious. To the extent what you're doing is different than everybody else, is it obvious to go from their design to your design? You know, what kind of innovation's involved? But if it's non-obvious, check. If you're the first to file in the patent office, you got to be the first to file. So it's a race to the steps of the patent office to file. And then you have to be able to, you disclose in your patent application how you build it and how you use it, so that someone else could make it themselves. They can't make it for 20 years, but you have to disclose it in a way that in 20 years from now, everyone can build this thing and make it and sell it. Okay, let's go, maybe we just go to, there's some really interesting things about patents, but we'll skip those for now. Provisional patents, though. Okay, oh, is that, wow, that's Willie.
Trademark violation.
I almost didn't know. That's with the sheet. Have you guys heard of provisional patent applications?
Yes, sir.
Yes, a little bit. So here's the thing to know. I told you how expensive patent applications are to file. From preparing it to issuance might be 20 grand. The U.S. government has done something special called a provisional application. It costs $150 to file. Costs $150 to file. And you basically, instead of having things done in a formal way, like a patent application has to be filed, there's a lot of precision that has to be done. A provisional, you just basically just throw stacks of paper at the patent office and you put a cover sheet on it. And you just say, I've invented something, it's all in here. These 100 pages of documents and figures I'm giving you, it's all in here. I'm going to come back in a year and formalize all this. You don't have to, but a provisional application expires after 12 months. So it's just to get a placeholder. I told you it's first to file at the patent office. So if you want to just get there and you want to get a feel for what's out there in the marketplace and if it's really worth spending money on this application, then you can file a provisional, kind of gauge things. If you decide, yeah, I want to go for this, then you can get with a patent attorney and actually do the formal filing. And as long as you do that formal filing within 12 months of when you filed this provisional, you get the provisional's filing date. So you get that filing date from a year earlier, and in that way you beat a lot of people to the patent steps. So I recommend for startups, small businesses, money's tight, a provisional application is a great way to get something on file. You can look on the internet and you can learn how to file one. It's meant to be able to be filed by non-attorneys. And it's really helpful. Say you're wanting to talk to a company about something you're doing. You want to have them maybe manufacture what you're doing, but you're afraid they're going to steal your idea. How do you stop that? Well, one thing you can do is you can put forth a non-disclosure agreement with the party you're talking to and have them sign this agreement where they agree contractually that they will not disclose what you've talked about. But people break contracts all the time, and if there's enough money there, sometimes people do things that are not good and they'll steal your idea. If you filed a provisional application before you talk to that manufacturing company, even if they signed a non-disclosure agreement, if they tried to then go out and copy what you were doing, and you continued on the other end to work with your patent application and move it forward, if it became an issued patent, you could go after that manufacturer and sue them for patent infringement. So using a provisional patent application in conjunction with a non-disclosure agreement can be an effective way to protect an idea that you have. Copyright we talked about for a second previously. I said it's a collection of exclusive rights that automatically vest to someone who creates an original work of authorship, like a literary work, song, movie, or software. So the important thing to know about a copyright is as soon as you write something, create something that's original, has just a little bit of creativity in it, you write an essay, that's copyright protected as soon as you write it down. You don't have to file anything with anybody. That's protected. If you wanted to sue someone for copyright infringement, you would need to file your copyright protected essay with the Library of Congress and pay $65 to register it with them, and then you could sue someone in a court of law for copyright infringement. But you have a copyright, and this is an important thing to know. As soon as you write something down yourself, boom, you got a copyright. And if you have a copyright, you're the only one that has the right to make a copy of that, to distribute it, to perform it. If you want to speak out loud to everyone and read it out loud to everybody, you can do that. No one else can. Okay, let's start.
That's all automatic, right?
That's all
They
automatic.
have a copyright on this. They don't have to file anything. They just already.
You just already have it. And so
So anything like my notes here, I can be like, can't take those are copyright.
that's right. Your handwritten notes are copyright protected.
Interesting. Okay, thank you.
And sometimes people will say, well, I don't see that circle C down below, copyright 2022, then it must not be copyright protected. You don't have to put that disclaimer or notice on your work for you to have protection. That just gives people a heads up that, hey, I just heads up. I think this is important, and I'm protecting it. But even without that notice, it's still protected. So if you go on the internet and if you find stuff on the internet, images, photographs, poems, those are all copyright protected. And don't ever assume because it's on the internet that it's free game, it's public domain, because it's not. It's copyright protected. And as soon as you use any of those works, you can be found for copyright infringement. There's a few exceptions, some fair use exceptions, and some special situations. If you use something that's copyright protected, there won't be infringement. And oftentimes, if you go to a website, maybe the owner of that copyright says this is free for everyone to use. And so, if that's the case, if they're putting it out there in the public domain, you're free to do that. Sometimes they put terms on there. They'll say this image is free for everyone to use, but you have to make an attribution to me, the copyright owner, which is fine, right? And it needs to be in the lower right-hand corner of your website page, and it has to have a link that goes back to my site, and they start having all these conditions. And so even though in the very beginning you looked at it and it said, this is free for all the public to use, then there's conditions, and if you don't meet all the conditions, then you've breached that contract, in which case you don't have a license to that copyright. And so there's a lot of scam artists out there that will do this with, for example, photographs. And you want to use a photograph on a website, and you'll go on these databases, and maybe Google says these are all public domain images because they were released under maybe a Creative Commons license. But these copyright holders, like I said, will have some requirements sometimes that they kind of hide, make not so visible, or maybe you just don't think much about it, and then they're trolling the web to see who's using their image, and then they come after you and sue you for copyright infringement. And you're like, well, wait a minute, this is public domain. It's like, well, I said you had to link to my website if you use this image. I don't see a link to my website. And then you'll say, well, okay, I'll add the link now. No harm, no foul. And it's like, nope. Once you fail to follow the term of this agreement, the contract is void, it's breached, and the license that I was giving you no longer exists. So you've been infringing this image, this copyright, ever since you posted it. So you have to watch out for scams like that. That highlights copyrights. Any other questions on that? Trade secrets. Let's just talk about this for just a second. I talked about a trade secret can last forever. If you have a certain way you do something in your business, maybe a procedure, a way you, data that you've collected about competitors and you've organized and you use in a certain way to help you be more effective in marketing. Anything that's helpful that provides economic value to you, information that provides economic value, competitive advantage, that's not generally known outside your company, and if you're taking reasonable measures to protect it, then you can say this is a trade secret. And that's really important because if someone takes that information that you're protecting as a trade secret, you can go after them for misappropriating your trade secret. So let me give you an example. So you have a company and you have someone that's worked there well for a couple years and learned how you do something within your company, maybe your software company. They leave to go work for a competitor. And they know some of these things that you've been doing in your own company. Under trade secret law, if you have been trying to protect that trade secret and you've been doing reasonable things to protect it, you know, maybe you have a security guard, maybe you have passwords on your computers, maybe you tell your employees regularly, the things we do here in this office, this is confidential. This is not to be disclosed. Maybe you have all your employees sign a confidentiality agreement. But all these different things that you do to show that you're making an effort to protect this trade secret information, once it gets out, if the company that gets that secret information, if they did it inappropriately, you can sue them for trade secret misappropriation and you can shut them down. So if that other company hired, so I'm company A, if company B hires one of my employees and I've been protecting this trade secret information and this employee goes to company B and discloses it, I can go to that company and say, you know, you can't use this information. Maybe you can't use that employee because he's just inevitably going to disclose this information even without trying. It's so embedded in his head. I mean, this is, so that's why trade secret can be a very valuable way to protect what you're doing as a business. And conversely, you need to be very careful on the other end when you're hiring somebody that you're not bringing in someone else's trade secret and exposing that to your own business. And so best practice would be if you were hiring someone, you understand where they're coming from and you ask them, do you have, you know, did you become aware of trade secrets that you're not supposed to disclose? Do not use those here at our business. We don't want to know those. And you might have a document even that you have the employee sign that says, I agree I will not disclose trade secret information in your business. So these are important things. I was thinking just real quickly of a case in law school relating to trade secrets, and it shows how some things have changed a little bit, but I think it was DuPont Corporation had this new way of producing some sort of chemical, and their competitor wanted to know how to do it, but DuPont was keeping it as a trade secret. They weren't sharing it. And this company wanted to know. And so when DuPont, this is in the early 70s, was building their plant, they flew an airplane over the top of the plant and started taking photographs as this was being built. So they could, I guess it was such that this process was distinct enough, but by seeing how they laid things out, this competitor could understand the process that was being used. DuPont took them to court and said, they have misappropriated our trade secret, and the courts ruled that DuPont was doing everything reasonable to protect their trade secret, and someone flying an airplane over the top of when you're building a business, that's unreasonable, an unreasonable discovery of that secret, and so they couldn't use that. Fast forward to now, where we have drones and information the way we do, maybe now DuPont would have been tasked with, you need to have tarps up to conceal this because it's reasonable that many people can see what you're doing. So it's a reasonableness standard, and a jury would decide, are you as a company, are you making enough efforts reasonably that you're trying to protect it, and if so, if someone else gets it inappropriately, they can be stopped from using it. Trade secret. Okay, let's have questions. I know I didn't answer a lot of questions. Go back to our chart.
And if anyone has questions, we'll use the mic for it.
Okay, one of the questions was designs, prototyping. How do you know it's yours and how to protect it? Great question. People are designing things all over the country, all over the world. You come up with something, how do you know that you were the first one to invent it? It's hard to know. So there's a couple different strategies. Some strategies are you just file on it and let the patent office figure all that out. That's one approach. Another approach is you spend some time doing some research and trying to figure out what's out there. You get on the internet, you get on the patent office's website and start looking for what's out there and getting a feel for if other people are doing the same thing that you're doing. And there's pros and cons of each. If you spend time searching for what other people are doing, you might spend enough time and money just searching that it would have just been better just to file a patent application. It's the government's obligation with the patent application to do the searching themselves. So one thought is just you file it with the patent office. It's their burden. Let them deal with it, and you go on your way and keep working on something. So it's hard, yeah.
Can you explain what a patent troll is and how to protect yourself from it?
Yeah, so a patent troll, there are companies out there that don't make a certain product, but they build up a portfolio of issued patents. They go out and buy issued patents from companies. So if they have this portfolio of this technology that they have no interest in using themselves, and their sole purpose of building this portfolio is to then go after and sue potential infringers. That's what a troll is. They've been very successful in the past. As far as how to stop them, they've enacted some laws recently trying to limit damages that a troll can collect if they're not actually producing the product themselves. But to be honest, I'm not totally up to speed. I haven't worked in that area close enough to know where we are with the law versus with trolls. So there's always this kind of push or this balance. I mean, our country believes, in fact, it's protected in the United States Constitution, patents. You know, it's something that was added in the original document. And so our country believes that patents are important to move technology forward, but you have people that are savvy and have learned that they can get a lot of money out of people by buying these as assets. And that just leaves a sour taste in some people's mouths. So it's like, where do you balance this all out? A little bit of an answer to your question. Other questions?
Well, mine is just that ours was denied, so is there any way to just want to go for a different lawyer? Like, would you hire a different lawyer, or would you just keep trying to appeal yours, or is it just dead in the water, I guess?
So in your specific question was trademark, right? So an important thing with trademark is a trademark protects a classification of goods that you're selling. I mean, so you can see the same mark being used in multiple different areas, right? I mean, you have Delta Airlines, you have Delta Faucets, you have Delta, they make pens, all different companies, but you don't confuse them for each other because you don't think that Delta Airlines is going to be making a Delta pen. They're in different classifications. So when you file a trademark application, you say, I want to get a trademark. I want to register this mark for this word or this logo for this type of goods. And maybe what you found then is someone else was using that same mark for that same type of goods. And if that's the case, it would be denied because they're not going to allow two to have that same mark. So if that's the reason it was denied, someone else is already using it and they beat you to it, there's not a lot you can do. Trademark goes to the first to use though. So if they beat you to the trademark office, but you were using your mark before them, you have rights. And that's where a lawyer can help figure out, parse where this is at. Because if you're the first user, you potentially could oppose their mark and get it canceled and get your mark put in place. Without even registering your mark, just by using a mark on a product and selling it, you have a limited trademark just without doing anything. And its value or scope is kind of the scope of the general area community that you're living in. So if I started selling a blender bottle here and didn't register that mark, I might be able to assert that I have rights to that mark in Utah County. But if you register it with the trademark office, you get automatic rights for the whole United States. So that's the power of registering it federally. So I don't know the specific case there, but and the trademark office looks at things. If it's not exactly the same, then the question is it confusingly similar? And that's a gray area then, and maybe it depends on the examiner that you get. But if it's a little bit different, is it enough the same? And maybe a different examiner, maybe a different attorney might be able to help.
Okay, so Eric, you work for UVU. Are you available for students to come and talk to you about any copyright questions they may have in the future? And if so, how can we best get in contact with you?
Yeah, so I would be happy to talk to any of you if you have general IP questions. I will leave a stack of some business cards here on one of the tables right here. In fact, I'll put it right here. Feel free to schedule some time to meet with me. If you go to the UVU's website, if you go to the Tech Transfer website at UVU, there's a place where you can see my availability and actually schedule some time for a phone call or to meet in person. So I'll leave those here. And then again, just a reminder, just with a caveat, again, I'm an attorney. Attorneys, where you represent clients and we have an obligation, duty to that client. My client is the university, so that's who I have a duty of loyalty to. And so I would be happy to talk general questions, answer general questions if we keep it kind of high level. Yeah.
So I'm a student here, I have a product, and I want to talk to you about it. Or I just don't know how it works with who owns my product since I'm a student working with people here on campus. Like, how do I maintain my product as mine? Or at what point does it transfer to university?
Yeah, thank you for that question. The university operates with policies. If you go to the university's website, you can see all the policies that the university has. The university has an intellectual property policy that talks about, with faculty, staff, students, who owns what when something is created at the university. So there's a policy, it's on the website. You can reach out to me and I'd be happy to walk through the policy with you and we can see how it plays out with what you're talking about. And then just generally speaking as a student, just know, generally speaking, you as a student own whatever you create. The university very much wants it to be, they want the students to be able to own what you do. The only time it changes really is if you're working on something, a grant, so a bunch of money has come into the university to fund some research. If you're working on a research project, that grant might dictate that the IP is owned, not by the student. And if you're using significant university resources in what you're doing, that might be another case where the IP policy would say that the university owns what's being created. But otherwise, things that ideas you come up with in class or work on in assignments, the student owns that. Yes, Megan?
We have a grant through the Super Startup Program where we give students money to work on their businesses. Would that fall under the type of grant you're talking about?
So that's a great question. So there's some money, it sounds like, that goes to students to help with some of your startup businesses. You look at the IP policy and it says if the university is providing significant resources, then the university owns that IP. So is the $500 or whatever did you say 500 or 300 or?
500
So is that significant university resources? I don't know for sure. So what I recommend is that let's get down in writing what it is that you're getting. You know, the university is providing $500, and let's have, you know, the university, if the university agrees, we're going to agree that this is not significant resources. Then we have in writing by the student and your department that it's not university intellectual property, and then there's no questions later. It's an area that's probably gray, and I would recommend that we put it in writing.
All right, let's give Eric a good thanks for coming and teaching us about IP. We really appreciate you coming in and teaching us about that. We also have lunch, so we have sandwiches back in the conference room. So thanks for coming. Let's go grab food. If you guys have any questions, I think Eric's is going to be hanging out for a little while, so you just come on by and ask him any further questions.
If you come